Hello and welcome to Business Talk, brought to you by the Sharonville Chamber of Commerce. I'm Brent Scarce with Emory Federal Credit Union. I'm your host. Today here in studio, we have Karl Ulrich with Sebaly, Shillito Dyer and Pandy Pridemore from the Human Resource USA. And we're going to be talking about internal investigations. Karl, Pandy, welcome.
How are you, Brett?
Thanks. Good to be here.
So internal investigations, what is an internal investigation and when should we have one?
Well, internal investigations can come up in a lot of different contexts. Somebody brings a complaint about a coworker. You might have a legal obligation, for example, to do an internal investigation. Or there might be a legal compliance issue that needs to be investigated. But there's something happening within a workforce that needs to be explored, understood, and responded to. And so an internal investigation is a way to get at the truth.
So would this center around perhaps harassment or theft or just somebody doing things you're not supposed to do in general?
Yes.
So, Pandy, you have a few examples of that?
A few examples of theft?
Wrongdoing?
Let's just watch the news. Let's just watch the news. And, that's what's so interesting is that people underestimate the importance of an investigation and all the finer details that need to be considered once an investigation needs to be or should be initiated. That's why we thought the topic would be really, really good because so very few people, again, how many training sessions are employers given the opportunity to participate in that go over this kind of stuff?
Right.
And it can make or break a situation when it gets to a point where it has to go to a Karl.
Right. That's it. When it becomes a legal issue, Karl, who should do the internal, investigation? I mean, I'm sure there's a lot of, if the owner of the company says, well, I'm going to investigate, and of course they may have bias, they don't want their favorite employee to be in trouble, or maybe it's a family member that works for them or something like that. Or you're smiling knowingly that those sorts of things have happened.
I don't have to make this stuff up.
Yeah. But Karl, I mean, who do you think should do these?
Well, again, it depends to some extent on the circumstances, but the choices are you have somebody internally, sometimes within the HR function, who is empowered to do that investigation. But oftentimes, if it's the type of a complaint or the type of an issue that is best investigated by an outside source, you might bring in an attorney or you might bring in an HR consultant, somebody from the outside who can take a kind of objective, fresh look at the issue, and that's oftentimes very useful. And there's some real advantages, both legally and practically, to having an outside individual at times do that investigation. Sometimes you want to be able to use the investigation, the fact of investigation, as proof that you did the right thing, as a legal defense in a lawsuit, as a training tool, and there may be reasons why somebody from the outside is best able to serve those functions. But that's not to say that in every case an outside person is always the best person. Sometimes it's an HR person, sometimes it's a corporate executive, but there may be different ways of conducting investigations depending upon the nature of the complaint that is the topic.
Okay. Yeah, I mean, you always hear on the news, you always hear of certain people having to recuse themselves, a judge or an attorney or some particular individual having to recuse themselves because they were somehow close to the situation or they're related to that individual. I can think of small companies that usually there are family members and people. It's very hard to detach yourself away and be objective.
Well, and this is one of those areas where very, very few companies have a policy or an established protocol for doing one of these and properly collecting information. And there are certain ways that you should be doing it, and there are certain ways that you just should stay away from. So I would certainly recommend, and I know Karl totally agrees, that every company should at least consider the possibility of having to do an investigation and put together a protocol, and then at all times have a policy of no retaliation.
Yeah. So the boss shouldn't just bust open the doors in front of everybody and start yelling at somebody and
Really? Do it in front of me.
In front of all
Please, do it in front of me.
Doing it in front of all the other employees. I mean, I can think of times in the past that there were bosses that would do stuff like that.
I was in a meeting where one entrepreneur decided he was going to take his fists and pound them on the table.
Oh.
And that was a great conversation. I live for that stuff. But again, that's that in perception of retaliation. Mm-hmm. I can't open my mouth. I can't be a part of this investigation. I can't be a part of this. I got to stay off to the side, which is just horrible for a company.
Yeah,
That
creates
is,
a hostile work environment.
well, it just creates all sorts of things about 3 feet deep.
Maybe one of them, yes. Yes. Yeah.
So it's possibly a real good idea to get a non-biased third party come in. Should that be an attorney, or are there just other HR consultants that you would bring in for something like that?
I think the training is the important part.
Yeah, I mean, I think it can be an attorney, but oftentimes, the fact that you're doing an investigation is evidence unto itself. You want to be able to show this is what we did to respond to the complaint, how we reacted to the findings, we did the right thing, we complied with our legal requirements. And if you have an attorney who happens to be representing the company doing that investigation, that attorney then is going to be a witness. And it works at dual purposes. I always tell people, if you're going to have somebody from the outside do an investigation, it's probably best that it not be someone who also advises the company. Yeah. That also, whether it's an HR consultant advising the company or an attorney advising the company, because you've got already a conflict there. You can't be objective and an advisor at the same time. If I'm called upon by a client for a sexual harassment investigation, and their first question is, well, can you come in and do the investigation? My response usually is, well, maybe we ought to get somebody from the outside, a consultant, someone like Pandy, to come in and do the investigation, because that person's going to be a witness in the case. I may defend you if you get sued, but I don't want to be in a position where I'm your witness and your legal advisor. That is going to undermine my credibility as a witness and not do you any good either. So we want the person doing the investigation to be purely objective and not in an advisory role, but solely for the purpose of, if you're going to make a recommendation about the response to the investigation, and that alone. That's your sole charge, and all the other stuff then is independent of the role of the investigator.
Okay. Let's go one step further, though. Not only is that very, very important, the duty of inquiry, but let's talk about the timing. One of the most crucial parts of an investigation is the timing. You cannot delay on these kind of things. And it's better to be on the side of caution and try to start or at least initiate an investigation if it doesn't even go any further than 1 or 2 questions, 1 or 2 people. But the fact that if you don't hit it promptly and you wait 2, 3 days, weeks, months, it just becomes disastrous for the company. So timing is very, very important.
Well, people start talking, start sharing at the water cooler.
Well, in a sexual harassment context, for one thing, one of the we talked about that the last session. Sexual harassment requires that the company do a prompt investigation and take prompt remedial action. The emphasis is on the word prompt. If you wait 3 or 4 weeks, not only does the evidence become stale, people's memories begin to fade, and they're not as they don't recollect all the important details that you might need, but you're also not responding quickly enough and protecting the rights of the potential victim. You need to respond quickly as a legal requirement. In addition to that's just that's just the right thing to do in an HR context.
Right. You don't want them to have to continue to work.
Exactly.
With that person that is harassing them, and have that just continue to get worse and worse.
Or even in a pure legal compliance context, something wage and hour context. Somebody brings a complaint about a wage and hour problem, and you wait 4 or 5 weeks to investigate the fact that the complaint that somebody's not getting overtime. You're already creating additional legal prejudice and creating additional legal issues for you simply by the delay. So you want to respond as efficiently and as quickly as possible to these complaints, and that means, all hands on deck when you get a complaint that needs to be investigated.
Well, let's talk about some of the best practices, Pandy. You were talking about, training and things of that nature. To recognize, I would assume employers need to know and train their management staff when to recognize when an investigation needs to happen. Like you said, time is of the essence. How do you train folks to understand that and not just think it's day-to-day stuff? Oh, it's no big deal. I don't really need to be that concerned about this. You think about the everyday person going to work. They're not always thinking about all the legal consequences of their actions and whether or not they act quickly and that sort of thing. So
well, and things that we want to train employees on, no matter what the size of the company is number one. Again, we have a no tolerance on certain topics. We also have an open door conversation. You have the right to jump over your supervisor or get to help at any one time. Supervisors cannot hold that information. They will be personally liable as well. So we have to train the supervisors to open that communication and allow the company to
So a supervisor that doesn't really want their boss to know there's a problem, that basically the person's coming and, you know, an employee's complaining to them, or maybe
Exactly.
they have a problem actually with them and they just keep sweeping it under the rug and just
Yes.
never let it, you know, many times the boss, the owner perhaps might not even know anything's going on.
Yes.
And I
You're
think
saying
another
that person could be legally,
Individually,
individually
absolutely.
liable.
And I think another important best practice when you develop a complaint policy, which I think every sizable organization really ought to have, some policy which tells the employees where to go in the event you have a concern or a complaint.
Mm-hmm.
And I think those points of contact are very important. I think more and more companies are going to an internal point of contact, somebody internally within the company to whom you can report a complaint, but also adding someone external to the company. And the reason you do that is so that if for some reason the complaint involves a higher level leadership person, you have an outside contact to go to. Now, sometimes that may be outside general counsel. Sometimes it might be a board member or somebody who is in some other kind of supervisory role. But someone outside the organization who's not present on a day-to-day basis should be an alternative. Always have that option for somebody to raise a concern. That's just good corporate governance, but it's also, I think, useful for the employees as well.
Sure. I mean, you know, we mentioned it earlier, but retaliation is just, you know, I'm sure you see that all the time.
Well,
especially smaller companies, they feel like I'm the boss, I can do whatever.
And they don't realize that that's exactly what they're doing. So let's go back to best practices. We want to make sure we've got the right people involved in the investigation at the right time. So again, don't wait 3 months to draw in the other individuals, and explain to them when they're in the process of the investigation why they're there, what brought this to fruition. And something we haven't touched on that we really should talk about is that the investigation should be between the designated individual and the employees involved, but there should also be a witness there documenting everything that's taking place. We've got to, you know, many times I'll tell employers if they're calling me and asking, you know, what do I do? I say, well, take a note from the Law and Order shows. What happens when you're investigating? You take a piece of paper, you shove it over with the pen and say, share with me there. Mm-hmm. And it's amazing, people are more honest and show more detail when they're writing and having to sign their name, but you need a date and all those nice details with it as well, but everything has to be documented. So that's probably, because again, that's the kind of stuff that's going to go to a Karl.
Yeah.
And if he doesn't have all the documentation, he can't piece it together, and the more time that goes by, the less people's memories go in.
Yeah, so when it goes to the attorneys, that means there's a good chance it may show up in a courtroom. And obviously the details.
I tell employers, paper towel, toilet paper, tissue, don't care. If you can write it in a crayon, we'll doctor it later. Just get me the facts, get the details, and show goodwill. You know, go through the inquiry. Go at least get started.
I think another challenge is confidentiality. I think a lot of folks, when they're especially internal people, when they're conducting investigations, will tell their witnesses when they're interviewing people, you know, I'm going to hold this and tell me anything you can remember, and I'm going to keep this completely confidential. The problem with that promise, however, is that it is impossible to satisfy, because if I'm interviewing a witness, there may be details that I have to ask the next witness about. In other words, information, for example, from a victim who comes in and complains about sexual harassment. I can't guarantee confidentiality because I can't investigate the complaint unless I can share the details with witnesses to get their verification. Right? Did this in fact happen? Yeah. And did you see so-and-so interact? There are certain aspects of the investigation that can't be confidential. Let alone the results. We have an obligation to go back to the person who's made the complaint and say, here's how we conclude. Here's what we concluded. Either we agree with the allegations or we don't. And here's the actions. Here are the actions that were. There are certain aspects to the investigation that require communication, and you can't maintain absolute confidentiality. If your policy says that, you've got to take it out. What I would recommend you typically say is, we'll keep it as confidential as we can be. Information will be shared on a need-to-know basis only, and that's probably the standard you want to follow in an investigation.
Well, let's talk about policy too, because we've mentioned this in earlier shows, but one of the clauses that I like to add into the handbook normally under the sexual harassment area or work rules, but require that employees participate in investigations. You have every right as an employer to require that your employees, if asked, must provide, participate in the investigation. If they provide false information, then that's another whole issue. But it is very important to have everyone participate. When you don't have individuals required to participate, then you're only going to get half the story, and you won't get resolution.
Well, I wonder. I mean, if they choose not to, Carl, I mean, I would assume they could be subpoenaed.
Well,
we don't get that far.
You know, hopefully you don't ever get to the point where you have to subpoena them. But yeah, I mean, ultimately, if a case goes to court, somebody who is a reluctant witness can still be forced to testify. But I think that's a very good point that Pandy makes, because I think we have an obligation to our workforce, if we're managers or if we're supervisors or if we're business owners, legal counsel, consultants, whatever. We have an obligation to the workforce we represent, and part of that obligation includes investigating issues among the employees. It's to safeguard the entire workforce from bad conduct, and that's a shared responsibility. It's not just a top-down responsibility. It's a responsibility among all the employees to participate in the process of ensuring that everybody is provided a fair and equal workplace. And I think that's part of the message here. And yeah, I mean, I think if an employee refuses to testify or refuses to share information, they can and probably should be disciplined in most cases.
Mm-hmm. Yeah, I mean, I know that there are, sometimes workplaces where people fear, hey, if I help out with that, then, that's going to affect
tragic.
Yeah.
That is absolutely tragic. Yeah. That goes beyond bullying. Mm-hmm. That's what I encourage all my employers: a safe and secure workplace. There's nothing better you can give to your employees than a safe and secure workplace. Absolutely. So, So, did you learn anything about investigations?
Absolutely. This was great information. Pandy, Karl, really appreciate you coming in and sharing this. Hopefully, we get a lot of folks to watch this and take this to heart and start to put the best practices in place and make sure that, like you said, we have a more open and safe workforce out there. So. Till next time, you've been watching Business Talk here, brought to you by the Schererville Chamber of Commerce. I'm Britt Scarce. We'll see you on the next show.